session today, it is an update, but it essentially splits into two main parts. A look at diversity and inclusion, and then other news. So thank you so much to those people who've submitted some pre-session questions. We do only have the hour, so we have had to focus on specific areas for the update. And as such, I am very conscious we may not be able to cover all the issues people have inquired about. I think it's possible some of the inquiries may be suitable for other sessions. There was a real theme of people being interested, for instance, in the future of the workplace. And I'm sure CIPD will have a look at that. Also, you'll be asked to participate in a survey at the end of this session, and you will be asked about future topics. So please do also respond to that. Now, aside from that, we will, of course, endeavour to answer as many of your queries as possible, whether we intended to cover those today or not. So do please post questions in the chat. Depending on which of us is speaking, Sal or I will try and answer bits as we go. And as I say, hopefully we'll get through a lot of your questions. Rebecca, if you're able to move on the slides, please pass that one as well, if that's okay, the next slide, thank you. So why focus on equality issues today? Well, equality is really high on the government's agenda, and that's been reflected in the number of developments we're expecting to see in employment law this year. Timeframes, well, what's been said is when parliamentary time allows. So timelines are not entirely nailed down, not as specific as normal. For obvious reasons, there's been so much other legislation having to go through almost as an emergency through Parliament. But this slide highlights some of the issues on that agenda. And what I want to do first is take a little bit of time to look at each of these in turn. So if we could move on to the next slide. So this shows some of the developments we are expecting. So taking ethnicity pay reporting first, Parliament will be debating whether to widen the scope of pay gap reporting beyond gender, so that the pay gap between employees of different ethnic groups must also be published. Now, there are several difficult issues that will need to be considered. For example, whether reporting should be between white and all BAME staff, or whether there needs to be a further breakdown of ethnic groups. And if that's the case, in which case, how should those ethnic groups be categorised? Now, research carried out by the Office of National Statistics, quite recent research, suggests that the gap between the average earnings of white British employees and 10 ethnic minority groups is the largest in London, and that's running at about 23.8%. So that's quite shockingly high, I think, and does highlight a need for employers to have some encouragement, whether that's sort of stick or otherwise, to address the issue and to really try and focus on building more inclusive workplaces. Now, many large organisations are already voluntarily publishing ethnicity pay gap information and demonstrating their commitment to the issue. Our poll that we're going to do in a bit is around ethnicity pay reporting, and just maybe testing with the group that joined us today whether this is something that you're all looking at, and if so, to what extent. So next to mention is tackling workplace sexual harassment. So this is an area where we've seen various consultations taking place, and we're waiting for the government to confirm what action it intends to take. Now, one of the original proposals was that employers should be put under a mandatory duty to prevent harassment, with substantial financial penalties if they don't, so very much a stick. And the aim, of course, to ensure all employers to take the issue seriously. There's also been a proposal to extend the time limit for bringing all such claims, workplace discrimination and harassment claims, from 3 to 6 months. Now, that's got a couple of aims. So Firstly, to allow employers and employees additional time to pursue alternative means of resolving problems before having to revert to litigation. And secondly, to allow internal grievance procedures to be completed. Now, we've dealt with a number of claims for employers where proceedings have been issued, and basically they've been issued because the claimant felt they had little choice if they wanted to protect their position in relation to the litigation and time limits. But it's not terribly helpful to either side, because obviously once there's litigation there, the parties tend to be taking up positions which become much harder to move from. So we've seen litigation being issued when the employer is still working through a grievance process, and the grievance process then is just had sort of the aura of litigation hanging over the top of it. So I do think this proposal to extend time limits will be helpful for both parties, really. So finally, in respect to this slide, confidentiality clauses or NDAs. Well, the hashtag #MeToo movement, I think, highlighted to us all the risk of using NDAs in an unethical way, either as a threat or to silence those who've been treated inappropriately. Now, the government has said it will introduce legislation to curb the use of NDAs in employment contracts and settlement agreements in cases of discrimination and harassment. And the rationale is to ensure that all employees who have experienced that type of action have a meaningful route of redress. And the government intends to make it illegal for employers to prevent individuals from making disclosures to certain bodies and people, and to make it compulsory for individuals asked to sign an NDA to get independent legal advice first. And many of you, if you use settlement agreements, are probably already seeing that the way in which settlement agreements are now being drafted are very clear that they continue to allow appropriate disclosures to be made, and that they don't seek to curb disclosures where they may be protected. So if I could have the next slide, please, Rebecca. The next area of change is extending redundancy protection. So as we all know, the rule at the moment is that before making a woman on maternity leave redundant, an employer must offer her a suitable alternative vacancy if one exists. It's one of the few examples of positive discrimination that are applied in English employment law. Now, it's proposed that such preferential treatment be extended to apply from the point an employee notifies her employer of her pregnancy until 6 months after the end of her maternity leave. So quite a significant extension there, I think. And the European Human Rights Commission have asked the government to implement this urgently because of the increase in redundancy as a result of COVID-19, which I guess in this country is still being partially staved off by the continuation of the furlough scheme. But I think where there's a real concern is that there are now stats emerging that the pandemic appears to have had a disproportionate impact on women in the workplace. And that leading into a situation where we may see extensive restructuring is simply going to further impact women and their place in the workplace. So finally, for a look at this is in terms of the government's high agenda items, flexible working by default. So the Conservative Party has said in the past it's committed to making flexible working the default position for all employment contracts, unless an employer has a good reason for it not to be. So we've been expecting a consultation on that for some time. As at the start of February, CIPD launched a new campaign calling for the right to request flexible working to be a day one right for all employees, and for employers to advertise jobs as flexible. And some quite interesting research there that of more than 2,000 workers surveyed, 50% did not have flexible working arrangements, such as flexi time and part-time working, and 20% revealed that their organisation did not offer any flexible working arrangements. Now, I do wonder how, I mean, that was obviously a very recent campaign that's been released, and you do wonder whether the pandemic in terms of positive outcomes, may have actually pushed that agenda on a bit with some employers, but perhaps that still remains to be seen. So as a conclusion to this section, I mentioned that we'd like to test the water just to see where you are all at in terms of looking at ethnicity pay reporting. So Rebecca, I wonder if I could ask you please to launch the first poll. If I just reassure people, we can't see how you're voting in terms of identifying individuals. It's very much an anonymous survey, so just really interesting to see how you're looking at this. So we're just seeing the numbers come in. We've got a great number of you on today, 330. Wow, thank you all for making the time. There's just a few more people pressing the buttons, so we'll just... Okay, almost there, I think, in terms of numbers. Rebecca, I think if you want to maybe share those answers. So yeah, interesting. So there's a lot of you looking, 25% of you starting to look at how you might report on a voluntary basis. Still more the majority who don't plan to report unless you're legally required to. We did a similar poll a couple of weeks ago, and actually had slightly different results in that the majority were either already reporting or preparing to report. So it's obviously quite a mixed batch in terms of what people are looking to do. So thank you. I think we can stop sharing on that. And then in terms of practical tips, well, I think this section simply highlights the various likely equality changes that are going to be coming in, and what you can certainly do now rather than waiting to be deluged by change is be proactive, look at the areas that are under focus from the government. You know, test yourself in terms of how well you're doing as an employer in these areas. Where you think should change come, you're going to have to do the most work, and perhaps start to do some of the research and thought that you might need to put into it to make your business more ready for the changes. And obviously checking in with managers, making sure that they are displaying the right behaviours to their staff, and understand your policies in this area. So Sal, I wonder if I can pass to you at this point to pick up on some case updates.
Thank you for that, Sarah. So I'm now going to take you through 3 cases dealing with equality related issues. And the first of these 3 cases, if we can move the slide on, actually deals with an issue that unfortunately the pandemic has brought to the fore, as in recent months, sadly, a significant number of us have actually experienced some form of bereavement. So in this particular case, the Employment Appeal Tribunal considered when a reaction to grief is sufficiently severe and long-term to amount to a disability. Now, in respect of this particular case, the claimant, Mr. Igweki, his father had passed away, sadly, in June 2016. As a result of that, he was grief-stricken, having experienced pain, anger, and guilt. He'd suffered from a number of different symptoms, including fatigue, confusion, and anxiety, as well as a loss of concentration at work. Now, for a period of around a month, he drank alcohol excessively. Now, these are clearly not insignificant symptoms. However, at the time, there was very little medical evidence for the relevant period. There was subsequently a GP note supporting a diagnosis of depression, but that arrived only much later. So understandably, there were concerns about his performance in 2016. So as a result, in January 2017, Mr. Igweki had been told that he would not receive a discretionary performance-related bonus. As a result of that, he raised a grievance and in July 2017 brought claims of disability discrimination, race discrimination, and for an unlawful deduction from wages. Now, he claimed that his performance had been adversely affected by a grief reaction that he said amounted to a disability within the meaning of the Equality Act. Now, his argument wasn't that he was ill or unable to work, as actually during this time, he'd actually been able to work overtime shifts as well as a second job. Instead, he argued that since he could not perform at his normal level because of this disability, it was discriminatory to then withhold the performance-based bonus that were based on targets that had actually been set before his father had died. Now, as I'm sure you will know, a person has a disability within the legal definition of the Equality Act if they have a physical or mental impairment, which has a substantial and long-term adverse effect on their ability to carry out normal day-to-day activities. Now, at first instance, the Employment Tribunal concluded that Mr. Igweki was not a disabled person for the purposes of the Act. He had not shown that he had a mental impairment, and in fact, his symptoms were, and I quote, in many ways, a typical reaction to the loss of a well-loved close relative. Now, the tribunal also concluded that there had not been a substantial impact on his ability to carry out day-to-day activities. The lack of concentration that he had experienced did not prevent him from carrying out his duties. It was only his performance that was affected, and that was just for a short period until February 17, when it was back on track. And furthermore, Mr. Igweki had not set out any specific day-to-day tasks that he'd become unable to do. So, turning to the Employment Appeal Tribunal decision, the EAT in fact agreed with the tribunal and dismissed Mr. Igweki's appeal. They found that there was very little evidence, whether that was medical or otherwise, that the death of his father had had the effect on work performance that he claimed. Now, even assuming that he had, what evidence there was to suggest that the grief that there was a grief reaction, this was considered to be acute rather than long term. Turning now to the practical implications, and the next slide, the effect of bereavement, of course, will be different for everyone. In some cases, a bereaved person may well be able to establish that they have a disability, particularly if the bereavement has triggered the onset of depression or any other physical or mental health condition. But one reason why many cases of bereavement may not qualify for protection is because of the definition of normal day-to-day activities, which have always been interpreted in a fairly narrow way. The focus is usually on fairly basic activities: reading, writing, getting washed, getting dressed, cooking, and these activities take place outside the workplace. So not being able to concentrate on a task requiring application over several hours would not normally be regarded as having a substantial adverse effect on normal day-to-day activities. However, difficulty concentrating in general would. Now, particularly at the moment, employers will, of course, want to support their bereaved employees as far as they're able, regardless of whether or not they satisfy the definition of disability. Turning now to the second case that I'm going to cover today. This related to a Mr. Galen, who described himself as being of Indian origin. Now, Mr. Galen was employed as a senior data analyst. After his employment had ended, he'd complained that he'd been subjected to racial harassment by a colleague who we'll call Mr. P. Now, the employer investigated this and found that Mr. P had made racist comments, which Mr. P said were just, and I quote, racial banter. Mr. Gelman brought a claim for direct race discrimination and harassment related to race. The tribunal upheld the complaint of harassment related to race. The tribunal had found that Mr. P had made comments to the effect that Mr. Gelman should go and work in a corner shop, that he had brown skin, that he drove a Mercedes car like all Indians, and he was even asked why he was in the country. The tribunal also found that 2 managers had overheard a number of the comments made, but took no action. They did not properly address Mr. P's behaviour with him, nor did they raise the matter with HR. Now, an employer can defend a claim based on the actions of one of its employees by demonstrating that it took all reasonable steps to prevent the employee from doing that thing. Now, the tribunal will consider, firstly, what, if any, steps have been taken by the employer, and secondly, whether there were any other reasonable steps the employer should have taken. Now, that takes into account the effectiveness of those steps, as well as, of course, issues of cost and practicality. In this particular case, the employer relied on its policies and the training that it provided to Mr. P and the managers. The tribunal at first instance rejected the employer's defence and that said that it had not taken all reasonable steps. It described the training as being stale, no longer effective, and also that it should have been refreshed. Now, on appeal, the EAT agreed with the tribunal. The equality training had taken place 1 year and 8 months before Mr. Gelman began his employment, and around 2 years and 8 months before he was dismissed for poor performance. The EAT agreed that a reasonable step would have been to refresh that training. The fact that it needed to be refreshed was evident from Mr. P's comment, which he considered to be no more than just banter, as well as the way in which the managers had failed to properly react. The training had made clear to the employees what they should do if they heard unacceptable remarks, and they all failed to follow that guidance. Turning now to the practical implications and the next slide, the reasonable steps defence is not an attractive defence to run, but it is always an option of last resort if an employer is in a situation where one of its employees is likely to have found to have discriminated against another in some way. So the threshold for that defence is high. Most importantly, the case reminds us of the importance of providing high quality and regular training on equality and diversity, as this will be effective at changing behaviours and the culture within our organisations. Now, training must be reviewed and refreshed regularly, and training programmes rolled out on a regular basis. In this particular case, the judge advocated annual training. Not just that, but the training must be of high quality, as the EAT said, and I quote, "If training involved no more than gathering employees together and saying, 'Here's your harassment training, do not harass people, now everyone back to work,' it's unlikely to be effective or to last." The EAT said that any brief and superficial training was unlikely to have a substantial effect in preventing harassment. And I quote, "Thorough and forcefully presented training is more likely to be effective and to last longer." You should also monitor whether training is actually making a difference. Are issues being reported? Are incidents or allegations of discrimination reducing? Are you seeing fewer grievances as a result? And are employees showing that they understand the importance of preventing discrimination and the role that they each play in that? Now, clearly, training is just one aspect in ensuring that your organisation implements and enforces proper policies is also very important. In this case, the employer had an anti-bullying and harassment procedure, but it didn't refer to harassment at all, apart from in the title, nor did it mention race anywhere. So you should always ensure that your policies are comprehensive and effective too. Now that brings us neatly on to our second poll of the day, which I would ask to be kind of kindly launched by Rebecca. So we can see that that's started, and obviously the question is, how often does your organisation review and refresh its equality training? Seeing the answers come through. Seems to be a fair number in the I do not know when it was last reviewed at this stage. I'll just give it a few more seconds just to let everyone submit their responses. I think we can close the poll now. And we'll see from the figures that, you know, yes, the majority is, I do not know when it was last reviewed, and hopefully this case will be a helpful reminder to revert, go back and check, and, you know, perhaps that's a sign that it hasn't been refreshed very recently. And kind of pip into second places every year, which I think, you know, as per the judge's recommendation in this particular case, is certainly recommended. But obviously, ultimately, it boils down to ensuring that it's rolled out in a way that means that the training is actually effective and has impact on the ground. So thank you for that. If we could, I will now move on to the final case of the day. I think if we just roll back a couple of slides. Yeah, so we're turning to Heskett. The origins of the dispute in Heskett actually go back to the public sector pay freeze imposed by the coalition government after it took power in 2010. And ironically, the Court of Appeal's decision in this case was announced just 2 weeks before the Chancellor announced yet another pay freeze for most of the public sector in the 2020 spending review. Now, the facts of the case are as follows. Mr. Heskett qualified as a probation officer in 2008. He was effectively a civil servant working for an agency called the National Offender Management Service, or NOMS. In response to the public sector pay freeze, changes to the pay structure were negotiated with recognised trade unions. Under the old policy, a probation officer could progress 3 points up the pay scale each year. However, under the new policy, they could only progress 1 pay point per year. As a result, the period of service needed to reach the top of the scale increased considerably. In Mr. Heskett's case, the time required rose from 9 years to 17 years. Mr. Heskett brought an employment tribunal claim for indirect age discrimination. He argued that the new pay policy put those aged under 50, including himself, at a significant disadvantage when compared to those aged over 50. Now, as long as the new pay policy persisted, the older employees at the top or nearing the top of the band would earn significantly more in salary and accrue greater pension benefits than those lower down the band. By the time he brought his claim, Mr. Heskett was being paid more than £5,000 a year less than older colleagues who had already reached the top of the pay scale. The service viewed the change as a temporary stopgap measure and was committed to changing it so as to reduce the age discriminatory effect. The service accepted that the new policy did have a disproportionate effect, but argued that the changes were justified. Now, as I'm sure you'll know, in order to run the justification defence, an employer has to show that the measure was a proportionate means of achieving a legitimate aim. And this is under section 19(2)(d) of the Equality Act. So there are two limbs to this test. First, what is the aim and is it legitimate? And secondly, was it proportionate? Or were there other ways to address the problem which would not have the effect of disadvantaging younger staff? The employer's legitimate aim was as follows: to reward staff in terms of pay on the basis of experience and/or service, to ensure that public sector pay is efficient and cost-effective for the taxpayer, to promote staff retention, and/or to ensure that the pool of workers has the proper skill set. Now, was that aim legitimate? The court decided that it was. Now, in coming to that decision, the court looked at the established principle known as the costs plus rule. Essentially, it's a rule of thumb that an employer cannot rely on costs alone when justifying a discriminatory policy, criterion, or practice, or PCP for short. But an employer can put the issue of cost into the balance with any other justifications that exist. So in terms of the decision itself, the Court of Appeal said that the better approach was to consider how the employer's aim can most fairly be characterized by looking at the whole picture. If the aim was to solely avoid increased costs, then it would not be legitimate. The court said you could not ignore the constraints under which an employer is having to operate, which often include having to make choices about how best to allocate a limited budget. In Heskett, it was not just that it would be more expensive to change the policy to avoid the discriminatory impact, but that the cost was, as the judge put it, positively unaffordable. The primary focus then needed to shift to proportionality, the nature and extent of the financial pressures, and whether or not they could have been addressed in a less discriminatory way. This was a factual assessment for the Employment Tribunal, which had concluded in this case that the steps taken by the employer were proportionate, and this point was not challenged on appeal. Most importantly, the measures to slow pay progression were a stopgap measure, which was under review. So going back to the cost plus rule, that was the plus factor in this case. It was a stopgap measure, and the employer was committed to changing it so as to reduce the age discriminatory effect. So turning to the practical implications, and the next slide, the cost plus rule has survived largely intact. Discrimination still cannot be justified if the sole aim is to save costs. You always need to look for that plus factor that will get you over the line and mean that looking at the employer's aims as a whole, the issue of costs is not the sole or overriding factor for a policy which, on the face of it, disadvantages a group with a particular protected characteristic. So it's reassuring for public sector employers in particular that they need to balance the books and operate under budgetary constraints due to real-world financial pressures that can form part of a legitimate aim. But it is, of course, a fine distinction and will turn on the question of proportionality, which will, of course, be based on the facts of each case. And I will hand you back to Sarah.
Thanks, Al. So moving away from equality and diversity issues now and looking at some other news, there have been a number of other developments which are worth knowing about. Some, like the Uber decision, which Sal's going to pick up on in a bit, are probably getting more news coverage than others. I doubt we can beat the press publicity that the Meghan Harry interviews generated with our examples, but we'll see what we've got for you. So looking first at the key health and safety protections extended to workers. So this case was brought by the Independent Workers Union about health and safety protections that apply to workers as opposed to employees. So typically contractors, agency staff, bank staff, etc., not those with a contract of employment. So whilst most general health and safety protections apply to everyone, one key provision, Section 44 of the Employment Rights Act, on the face of it applies only to employees. That section protects them from being subjected to a detriment in a range of situations relating to health and safety, including where they leave the workplace because they believe there is a serious and imminent danger, or take appropriate steps to protect themselves or others from such danger. Now, health and safety issues have obviously risen to some prominence in the last 12 months. Having, I don't think, ever had an employer raise with me a Section 44 query prior to 12 months ago, we've had a number of employers report to us that employees have raised a Section 44 type argument in relation to objections, mainly with regard to returning to the workplace. The IWU's members mostly work in the gig economy as couriers, private hire and van drivers. So in less than 3 months at the very start of the pandemic, they received about 144 complaints about COVID issues. So things like lack of appropriate PPE, failure to implement social distancing, not packaging COVID samples appropriately, stuff like that. So the IWU decided to bring judicial review proceedings against the government, arguing that workers were not adequately protected and asking for a declaration that Section 44, amongst a number of other provisions, did not correctly implement the underlying EU directive. So the High Court has now confirmed that Section 44 should be read as extending not only to employees, but to other individuals engaged under a contract to do work personally. So they're commonly known as Limb B workers, after the relevant part of the definition of worker in the Employment Rights Act. So what's the practical implications of this? If we can move on the slide, please, Rebecca. So clearly employers do need to make sure they're doing everything they can to protect workers, not just employees, from a health and safety perspective. If they don't, workers can now bring claims against them. Frontline workers in particular are entitled to be provided with all the necessary PPE to carry out duties safely, and are now able to take steps to protect themselves, for example, by leaving work if they don't feel that adequate safety provisions are in place, or not turning up to work at all if they have a reasonable belief that going to work would put them in serious and imminent danger. Looking beyond health and safety law, it's another example of the fact that EU employment law tends to have a broader application in the workplace than the original UK legislation. For example, last year an employment tribunal ruled that our TUPE regulations should be read as extending to Limb B workers as well as employees. So even after these cases, of course, non-employee workers still end up with more limited protection than employees, simply because their general employment protection rights are less extensive. And of course, both of these decisions could still be challenged in our appellate courts. And what about post-Brexit? Well, the government could, in theory, change the law to exclude workers from the protection of Section 44, but I think for now there is a level playing field there and workers are protected. So the next case I want to deal with is a December case that focused on interim relief. And I'm quite sure that amongst the, I'm just looking at the numbers, the 340 odd of you who are on this call, there's probably quite a number who have not necessarily heard about interim relief. So just to give you a little bit of background, interim relief is a remedy that's only available where a claimant has been dismissed in certain circumstances. And if they want to go for interim relief, they've got to make an application within 7 days of the effective date of termination. So there's a really short window of opportunity there. Now, if their application succeeds, the employee can be reinstated or re-engaged if the employer agrees. Otherwise, in most circumstances, the tribunal will make an order for the continuation of the contract of employment, and that's on full pay, until the determination or settlement of the complaint. So it's a really valuable remedy to claimants, particularly at the moment where we're seeing really significant delays in employment tribunal listings. Now, it's not available in conjunction with all types of employment claim, but it's where the dismissal relates to issues such as making protected disclosures, or because of trade union related activities, or the activities of health and safety reps are a few examples. And to be successful, the claimant essentially has to convince the tribunal that they're likely to win at any final hearing. And that will involve the tribunal being satisfied that the claimant is likely to be able to prove that the reason for dismissal was the prohibited reason alleged, i.e. it's connected to a protected disclosure, for instance. So why is this case important? Well, as I mentioned, interim relief is available in only a limited number of jurisdictions. But in the December 2020 Steer case, the Employment Appeal Tribunal was asked to consider whether the failure to extend interim relief to dismissals for a discriminatory reason infringed either European Union law or amounted to a breach of the government's obligations under the Human Rights Act. Now, the EAT concluded that the UK had complied with EU law, but believed there'd been a contravention of the UK's obligation to ensure a fair trial under Article 6 of the European Human Rights Convention. Now, the EAT has no power to make a declaration of non-compliance, which would oblige the government to change the law. But this issue is now going to go on to be considered by the Court of Appeal, which does have the power to make such a declaration. So essentially, we're now awaiting an update as to whether a claimant's rights to seek interim relief will be extended further. And I think the extension of the possibility of interim relief to dismissals for a discriminatory reason could, I think, have a potentially massive impact on employers. So what are the implications of that? If we just move on to the practical slide. I mean, so at the moment it stays as is, and we don't see that many interim relief applications at the moment. However, it maybe just highlights to you all to be particularly sensitive where you're dealing with a dismissal which might include any kind of employee representative. That's quite often where this right or this option for a claimant is engaged. Whistleblowing is a particular risk, and in the current climate, it's quite important to remember that health and safety is one of the areas which has been singled out in the definition of a protected disclosure, i.e. one that tends to show that the health and safety of any individual has been, is being, or is likely to be endangered. And obviously these are the types of claims that we're seeing more of because of the impact of the pandemic. Okay, so I think it's back to Sal at this point to pick up some of the other news.
Yes, thank you, Sarah. So turning to the issue of COVID vaccinations. Now, I'm sure you'll have seen that there has, of course, been significant amount of press coverage around the lawfulness of making vaccinations mandatory. For instance, some employers choosing to take a no jab, no job approach. I understand that a number of questions were raised in advance, but there has been a previous CIPD and Mills Reeve session on this, and I believe that Rebecca will be circulating a link either in the chat box or even following this session. So in terms of making the vaccine compulsory, I think there is limited scope to do this, as there are multiple factors in play here. Such as the government itself not making vaccines mandatory for the general population, and most significantly, that there are infringement of rights issues, particularly in respect of religious and philosophical belief under the Equality Act. So the focus has been on taking steps to making the workplace as COVID secure as possible, which of course leads to similar questions around mandatory testing. Now, testing is of course less invasive than a vaccination would be, and the government has increased provision for workplace testing as announced, I think it was a couple of weekends ago, whereas previously lateral flow tests have been available to businesses with over 50 employees. Recently, it's been announced that workplace testing will now be available to all businesses, and businesses should register their interest by the 31st of March to access free workplace testing. Furthermore, Acas has also published new guidance on testing in the workplace, which is of course worth reviewing for those looking to implement workplace testing. Turning now to the key budget announcements, from an employment perspective, I'm sure you'll have all heard that the coronavirus job retention scheme, which was expected to end on the 30th of April following a previous extension, has now been extended again to close on the 30th of September. Now, as per the existing rules, for claims under the scheme up to the 30th of April, employees will need to have been on the payroll by the 30th of October 2020 to be eligible. However, in respect of the extended period from the 1st of May onwards, the payroll cutoff date is the 2nd of March 2021. Now, while there'll be no employer contributions beyond the national insurance contributions and pensions required in April, May and June, from July 2021, the government will introduce an employer contribution towards the cost of those unworked hours. This will be 10% in July, rising to 20% in August and September. Now, I appreciate there have been questions around whether or not there's any case law on the furlough scheme. Now, as far as we're aware, there's no reported decisions as yet. However, we are advising clients on furlough-related claims. While we hope our clients don't prove to be test cases, we do anticipate that there are claims that are going through the system, and I'm sure we'll hear about those in due course. Turning to the sick pay rebate for SMEs, currently eligible employers with fewer than 250 employees can apply to HMRC for a reimbursement of up to 2 weeks statutory sick pay per eligible employee, purely for sickness absence owing to COVID-19. This scheme has now been extended, and the government will set out its steps for closing the scheme in due course. Now, in terms of trainees and apprentices, in January 2021, the government announced that employers who created new traineeship opportunities could apply for a cash payment of £1,000 for each trainee they take on, up to a maximum of 10 trainees. Now, the scheme will be available until the 31st of July 2021, and employers can claim the cash incentive for all work placements that have been completed since the 1st of September 2020. More funds have been committed to this endeavour. In terms of apprentices, the government had previously announced that employers were entitled to a payment of £2,000 for each young apprentice taken on under the age of 25 and £1,500 for each apprentice aged 25 or over. Now, in the budget, the payments have increased, and for new apprentices between the 1st of April 2021 and the 30th of September 2021, employers will receive £3,000 per new hire. Turning to the next slide, and the discussion that I'm sure you'll have all had to date, but the Supreme Court ruling in the Uber decision was published on the 19th of February. Now, this was a test case that was originally brought by Yassine Aslam and other drivers to establish worker status. Now, as I'm sure you'll appreciate, Uber has always maintained that they were self-employed. The Supreme Court has confirmed that Mr. Aslam and his colleagues had the status of workers, not self-employed contractors, when working for Uber. Now, this is an express approval of the original tribunal decision from 2016, which was subsequently upheld by the EAT and Court of Appeal in 2017 and 2018, respectively. As workers, they'll be entitled to paid annual leave under the working time regulations and to national minimum wage for the period while working for Uber. The Supreme Court has confirmed that this includes not only the time they were actually driving, but also for waiting periods when they were logged into the Uber app and ready to and willing to accept passengers. Now, the Supreme Court approved the Employment Tribunal's focus on the high degree of control that Uber exercised over the way these services were delivered. This included setting the price, dictating the route, defining the contractual terms between the driver and passenger, and limiting drivers' freedom to decline rides. However, this does not necessarily mean that all Uber drivers are workers, as this case related specifically to the contract that Mr. Aslam and his colleagues were on, as Uber have periodically changed their contracts. Nor does this actually change the test for status, but it is a timely reminder that the courts will look to the actual reality on the ground rather than exclusively on the terms of any contract issued. Now, on the subject of Supreme Court decisions, you may have noticed from the chat earlier that we're expecting a decision on the MENCAP case relating to working time and sleep-ins, which is due to be published this Friday, the 19th of March, so keep your eyes peeled for that. We've also noted that the Uber decision was supported by the app drivers and couriers union, and we're seeing a lot more kind of union activism. The update that Sarah gave on the Section 44 case was supported by the IWU, and you may recall that judicial review proceedings that overturned the employment tribunal fees were brought by Unison. I'm not going to spend an awful lot of time talking about IR35, but you may recall that this was originally meant to be introduced in April 2020, but has now been delayed and postponed and will be implemented in April this year. Suffice to say that obviously the measures will impose a kind of a new tax regime on larger private sector employers when they contract with intermediary companies to supply an individual to do work for them. And it's the client company or end user that will be required to assess the status of these individuals and whether or not they kind of fall within the definition of employer and worker, giving rise to a tax and national insurance obligation. And just generally, there are kind of other plans to level out the playing field, and the government is rolling out an agenda to protect more vulnerable workers in the labour market. For instance, there was recently a consultation on extending the ban on exclusivity clauses in employment contracts to and beyond those in 0 hours contracts. This consultation closed on the 26th of February 2021, so we will await the outcome of that. And I will hand you now back to Sarah to kind of wrap up this morning.
Thank you, Sal. So that concludes our update. As I say, I'm very aware that some of you had questions that were not the focus of the session today, but hopefully everybody found it useful, brought you up to speed. I mentioned in the chat the fact that we weren't able to give adequate attention to the immigration issues today, but our firm is running an immigration update later this month, and you're all very welcome to book on, and thank you for CIPD for allowing me to mention that today. Rebecca, shall I hand back to you at this point? And we'll maybe have a quick look at it as well in the chat, just to see that we've picked up most of the questions.